Next case is LIGHTKEP versus State.
Morning.
My name is Sam Bennett. I'm here on behalf of George LIGHTKEP. May I proceed, Counsel? The reason that we're here is because there were, at trial, numerous mistakes that I believe need to be addressed. I'm going to go in my order unless, of course, you decide otherwise, but...
I guess in looking at the issues that you raised, I had a hard time pinpointing one that was actually preserved for appellate review. So do you want to maybe first address what issues you actually believe were preserved for review and why?
Okay. In my first issue, as far as the jurors, I believe that was preserved because at both times, the jurors, Ms. Burgos and Mr. Braddock, I objected to them being on the panel.
Did you object to the jury before it was sworn?
I did not specifically say no when the judge asked, do I accept the jury?
Isn't the case law very specific that that's a requirement for preservation?
It is.
And you also have to exhaust your peremptory challenges and ask for additional peremptory challenges if you're going to challenge
In that respect, while it's not the letter of the law, the way that it's in the case law, I felt that that was met because I did exhaust my peremptory challenges when it came to Mr. Braddock, because he was in the first group of jurors. And then he changed some of his answers when we came back for the second round. And when I moved to do that after we had our individual questioning of him, I moved to have him removed, and I was told by the judge that I didn't have any more left to do, no more peremptories. When I asked, is it my turn, can I, argue this, and they're like, she said, you don't have any more.
And I think the case law very clearly says what you have to do is say, well, I request an additional peremptory challenge. You denied my cause challenge on Mr. Smith, and therefore I'd like to get that peremptory challenge so I can exercise that with respect to Mr. Smith. I don't think it's appropriate for the jury. And I guess, the record doesn't reflect that happened, correct?
And that's correct. I did not, to the letter, follow that. I, after the fact, found out exactly what I should and shouldn't have done, but I do believe, if you read into it, that it was addressed. It just was not the exact way that it's outlined. The next issue I had was that I thought was an error was the detective being permitted to sit at the table. She was not considered to be a necessary.
She was the first witness called, correct?
She was.
And was not recalled thereafter as a witness.
That is correct.
So the prejudice would have been what? That she was there and heard opening statements?
Well, the prejudice, I believed, was that she was sitting at the table assisting the prosecutor throughout the proceedings when all...
Have you ever handled cases in federal court?
A few.
All right, well, if you've ever handled a criminal case in federal court, the lead agent always is at counsel table. Do you have any case law for the position that that's error?
The case law that I cited basically states that it is discretionary. It is not a given one way or the other, but the court does have the authority to, if they determine that the party is necessary.
Then what abuse of discretion flowed from allowing the detective to sit at table in this case?
Well,
was that an abuse of discretion?
From what I have found out, I would say that the abuse of discretion would be the fact of determining that she is a necessary party. She was not involved with any first-hand knowledge in the case. She only got information from other agencies.
What prejudice is there?
To the jury, it would appear that she's there to, in an additional fashion, other than testifying, to assist in the prosecution of the case.
So what?
I believe that looks, makes it look worse against the defendant, makes it look like he's guilty when in fact they haven't heard all the evidence.
Or it looks like they're ganging up on him.
Basically, yes.
Yeah, that could go the other way.
It could.
So it's somewhat speculative.
Yes, Your Honor.
Okay.
And did you object at the time?
I did object. I did not articulate a very good objection because that was never even brought up prior to that. I had no inkling that that was going to be an issue. So I did not articulate a very good objection as far as objecting to her being there. But I did make it clear that I objected to it, that I didn't think it was necessary. And I was overruled. Another issue that I brought up was the issue of dealing with favoritism. When I objected to a matter of that the prosecutor was mischaracterizing the evidence, the judge said, you can argue. When I tried to do the same thing, I was told, you can only comment on the evidence. And when these comments are being made in front of the jury, this comes across as being, at least in my mind and in my client's mind, as being showing favoritism. Why isn't the judge saying the same thing to the other side? Why is the judge commenting on the evidence? She shouldn't be, especially in front of the jury. It goes on, at one point in the questioning, which was perfectly normal questioning in the background information of the victim, I started to elicit some of the factual information, and the state objected. And then the judge, without any prompting, says, do you want to proffer this? Well, I agreed to that. I proffered the information when we took the jury out, and everything that I asked was admissible. But that shouldn't have even happened. One of the objections that the state raised was it may call for hearsay. That's not a valid objection. A valid objection is, if a particular question calls for hearsay, that's fine, but the fact that maybe it calls for hearsay, where do we draw the line as far as that goes? Are we going to go back and say, I object to the opening statement because, it's going to call for hearsay, or I object to the questioning of this witness because this may call for hearsay? I mean, where do you draw a line on that? It's a slippery slope.
And do you think that rose to the level of reversible error?
That alone, maybe not, Your Honor, but I believe in conjunction with a number of the other issues that were possibly preserved and others that were not preserved, when they were added together, I do. Another comment that the prosecutor made after he had said that, he says, I object, counsel made me lose my train of thought. I mean, that's just making a mockery of the whole trial. He shouldn't have said something like that. Makes him look bad, but that's his problem. If he lost his train of thought, that's his problem. It's certainly not a valid objection to put on the record in front of the jury. Also, when he talked about in the voir dire, he talked about... Go ahead. The prosecutor talked about what the defense has to do, what they have to prove, which would be an impermissible or fairly acceptable...
Wasn't the comment basically that the defendant has a right to remain silent?
It was, that's what it should have been, but that's not what was said. It was to the fact he was asking the jury, we all know what the defendant can do, but no one answered that.
I mean, the question there in voir dire was, do any of you think that the defendant ought to have to prove something or challenge the allegations in any way?
But then he went on
There
and
was
said...
no objection, right?
I did not object to that, but he then said, except we all know the answer. And he just left it like that, and he didn't clarify anything with them, he just moved on from that.
Well, no juror indicated that they thought that the defendant needed to present any evidence or prove anything, so...
It certainly made, in my mind, it made it appear that the defendant needs to get up there and prove that he's innocent. Additionally, with that...
You addressed that then during your voir dire of the jurors, to make sure they didn't have that misimpression?
I don't have my notes right here, but yes, I'm sure I did address that, Your Honor.
And the judge gave an instruction that said the same thing.
That's correct.
One of the difficulties in the reversible error concept that you're talking about is that there was a tape, admissions made by your client, controlled tape, recorded conversation that seemed exceptionally damaging when we look at this in terms of whether it was reversible error or harmless error if there was indeed error. Could you address that?
Well, Your Honor, the tape did not, my client never admitted anything on the tape. My client said, in like, go on, keep going type fashion. He did, in hindsight, certainly, he should have said, that didn't happen, you know, I don't know what you're talking about, and he didn't do that. But my client never said, you know, I'm sorry for what I did, or anything like that. The only comments made on the tape when there were hints of it, and they were not specific, not very specific as far as what was testified at trial, was,
Well, baby, I don't know what to tell you to ease your mind. When she says that, you know, she's been putting the police off, he says, you know, my wish is that you would continue to do that. You don't think that those are awfully incriminating statements?
they certainly are, yes. But he did not come out and say, yes, I did that, or I'm sorry for what I did, or anything along those lines. I don't know why he made certain statements he made, but yes, I do understand, I understand what you're saying.
Perhaps the jury can enlighten you as to perhaps why he made those statements.
I'm sure that was how they did. Additionally, though, Your Honor, in the closing, the prosecutor argues what's her motive in stating that, you know, to fabricate something like this, which is always a concern of the court in these type of cases, that does happen from time to time. And that, again, put the pressure on switching the burden to the defense having to prove that she made it up. That wasn't the burden. The burden was whether or not, beyond a reasonable doubt, was met that my client committed these crimes. And that at least, it appears to put the pressure back on the defense to prove that this did not happen. Additionally, one of my comments, and this was ideally to address recollection, when I brought up a comment about 9/11. I wasn't bringing up a hypothetical, I wasn't bringing up a golden rule issue, but the judge felt it was her responsibility to caution me on the golden rule anyway. I was just asking the jurors if they remember where they were. I remember exactly where I was, what I was doing, what I was thinking, all of that. And some of the testimony that came out was pretty vague. It's supposed to have happened 20 years ago, but if this was something pretty traumatic, you would think the person would remember this in pretty good detail. Instead, though, not only do they object to it, I get the cautionary golden rule, but then when
What you're saying to the jury is, well, you know, you would remember. You would remember exactly where, you know, you were at on such and such a date, with the implication being, you know, well, you remember this, she should have remembered that. Isn't that getting close to a golden rule argument?
it's getting close, but I don't think it's crossing that line. But in rebuttal to that, when the prosecutor got up there, after he commented about 9/11, then he came up with his own hypothetical involving himself and talked to a jury about that. And the court, the case law specifically says that the criminal trial is supposed to be a neutral arena. You're not supposed to be telling about yourself. You're not supposed to be bringing up these hypotheticals, because that is a golden rule matter. You're supposed to be about the facts of the case and your arguments. And the judge allowed that.
You're down to about 1.5 minutes if you want to save it for rebuttal.
Yeah, I think I will do that. Thank you.
Thank you.
Good morning, may it please the court, counsel. Again, Kelly Neal for the state. It's the state's position that none of these claims have been preserved for appellate review. None of them constituted fundamental error, and on at least 3 of them, claims 2, 4, and 6, they're not even sufficiently brief to present a cognizable claim for appeal. If the court doesn't have any questions, then I'll rely on my brief and ask the court to affirm.
Thank you.
Thank you.
Any rebuttal?
All I would say, Your Honors, is that according to the case law, some of these matters were preserved as a contemporaneous objection was made, a legal basis was given, and the objection was denied. Another matter that was brought up that I didn't speak on, but that was addressed, was when, prior to the case, or prior to the start of the trial, I had filed a motion to keep certain information out, dealing with other people that potentially, other victims and such, because there was never any evidence presented about that. It was just supposedly something that happened. The judge, the state agreed that they wouldn't bring that information up. Then, on direct testimony, the state elicited that information, some of that information, and I objected to it.
What specific information was elicited?
The fact that at the time, supposedly, when my client touched the victim, her mother was present.
Right, but that's not allegations of a crime against an additional victim, is it?
No, but that was specifically addressed in my motion. And it had been ruled that it was not to be stated. And it came out. I objected to it. I moved for mistrial, and the judge denied my request for mistrial, and then stated, cautioning me, not in front of the jury, but
If the victim's mother was present during an event, why wouldn't that be admissible?
she was never listed as a witness. She never testified. But the judge, instead of letting me...
Wouldn't that assist the defense rather than hurt the defense? That you had another witness present who wasn't called by the state? I'm assuming that witness was not necessarily equally available to both parties.
It could have. I didn't choose to argue that issue, that direction, but yeah, it could have, Your Honor. But again, I felt my motion was addressing that part as well, so it kept me from arguing that side of the coin as far as that goes. But the judge talked me out of giving a curative because she said, by bringing this up, you're bringing attention to this issue, and that's true. But that should be my problem, not something that the court should be telling me that I shouldn't do.
Thank you, counsel. Your time's expired.
Thank you.
Thank you, sir.
Next case